During your pretrial deposition in your medical malpractice case, if the defense attorney fails to ask you all the information about all the details in your case, is it your obligation to go ahead and volunteer all that information that you were not asked about? You want to know the answer? Come join me on this walk along the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. So, if the defense attorney turns around and says, okay, thank you so much, Mr. Jones, I'm done with my questioning, and you turn around and say, wait a second, you didn't ask me about all these things that occurred. You didn't ask me about all these details. I have so much more information. Is that your chance to speak up? Is that your opportunity to tell the defense attorney that they didn't ask you about all the details of your particular case? The answer is, no, it's not. You have gotten in your mind, or the perception at least, that a deposition, this pretrial question and answer session in your lawsuit, is your opportunity to go ahead and tell the defense every single detail of every single event that transpired in your particular malpractice case. Well, let me share something with you. I have to tell you that you are totally 100% wrong about your perception of what a deposition is. I'm sorry to say it. If nobody has told you the real purpose of a deposition, I'm going to do it. And here's what it is. The real purpose of a question and answer session is to answer the defense attorney's questions. That's it. That is your goal. Your goal is not to tell the defense every single detail of every single event of every single day that transpired in your malpractice case. That is not the purpose, and it is not the goal to do that. And think about this. If you were to somehow tell the defense every single detail of every single memory of every single interaction that you had, you would be there for many, many days, where every single interaction now would be questioned. And now they would ask follow-up questions, not just a few questions, but hundreds and thousands of follow-up questions. Why? Because they are entitled to probe and to learn information. This is the discovery phase of your lawsuit. This is what happens when you bring a lawsuit trying to seek compensation, trying to seek money as a form of compensation because your doctor or hospital staff was careless and caused you significant harm and injury. And when you do that, the defense attorney has an opportunity to learn from you and say, okay, Mr. Jones, tell us what happened. Why are you here? What problems do you have? What do you believe was done wrong? What do you think the doctor did to cause you this harm and injury? And now they're entitled to probe. And whatever answers you give, they're entitled to follow up and to ask even more questions. During COVID times, this typically will take place on a Zoom video call. And did you know that the answers that you give during this Zoom video call actually represent your sworn testimony? And it carries the same exact weight as if you are testifying at the time of trial. So now the defense is trying to learn about what happened. What interactions did you have with the doctor, with the hospital staff? What problems did you have? What communications did you have? Did you communicate with the doctor and the hospital staff in person? Was it by phone? Was it by text? Was it by email? They want to know about that because those conversations typically are not recorded anywhere in your medical record. So that is critically important to answer and to tell them about. Now, when you are asked questions, your attorney is going to tell you, listen, answer only the question. Do not volunteer information. And it goes back to the concept I was talking about a moment ago. Your purpose is to answer the defense attorney's question. It is not to go ahead and volunteer information and go off on tangents about something that they did not ask for. Now, here's the exception. When you are asked questions about the problems that you have now because of what the doctor did carelessly, now, that is your green light. That is your opportunity to go ahead and tell the defense lawyer about the problems that you have now, about your injuries, about your disabilities, about how you're no longer able to do your activities on a regular basis, about how you do things with difficulty and not the way you did before all of this happened. That is your green light. But in all other instances, you are not there to go ahead and volunteer any information other than what the defense attorney wants to know. So why do I share this quick information with you? I share it with you just to give you a sense of what really happens in these medical malpractice cases in New York. You know, I understand you're watching this video, you see the beautiful scenery, you decide to click on the play button and say, wow, that's interesting. No, I know you're not watching it for the scenery. You wanted to learn about what occurs during these malpractice cases. Well, here's my suggestion. If you're learning about this information and you have not yet started a lawsuit but are thinking of doing so, and your matter did happen in New York and you have questions that need to be answered, what I encourage you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.